Good morning, everybody, and welcome to a very special encore episode of Webinar Wednesday, the Friday edition. It is a very rare occasion when an issue presents itself to the HR community that brings out as many questions, concerns, fears, joys, triumphs as what we're dealing with here today, California's new paid sick leave law. As you can imagine, the phones here at Employers Group have been ringing off the hook for the last several months now with questions about this and for discussion about how best to deal with this topic that's in front of us today. Every one of us here at Employers Group has been pitching in one way or another to support our members, and our webinar this morning is another step in our efforts to assist all of our members in addressing this issue effectively. We have a lot to cover this morning, as Stephen was mentioning. We do expect about run until about 10:30 today, and again, as we pointed out, please go ahead and put your questions into the box at the bottom right of your screen, as they will do. We'll do our best to work them into the discussion this morning. Anything we're not able to cover, we will be getting back to you through an FAQ that will be going out sometime next week, addressing every single question entered into there. At the center of this new paid sick leave law here at Employers Group, I guess you could say the calm, the serene, the eye of the storm that is this, my esteemed colleague seated here with me this morning, Mr. Matt Bartosiak, a name familiar to, I would imagine, everyone who's joining us this morning, a senior consultant here at Employers Group who has worked for many years, working with thousands, literally thousands and thousands of Employers Group members over those years to provide guidance and support on issues such as California's paid sick leave law. And as in any type of situation we deal with here at Employers Group, we understand the compliance. We're always happy to talk to you about the compliance issues, but we also want to always look at the real world challenges. And we want to kind of focus on that as much as we can this morning in this webinar. There are a lot of questions that are coming to us that deal with the issues surrounding the implementation of paid sick leave. And that's what we'll spend as much time on as we can. But we know that most of your questions are going to focus on the applications. How do we make this work? What do we do at our company? What do we do in this particular situation? So we'll do our best to address those as well. As most of you may have noticed, we did conduct a brief survey over the last few weeks, and we got some great responses on that. I'm going to give Matt a couple more seconds to warm up his vocal cords and just walk you through some of the results of this survey, and it helps to tee up some of what we're going to be discussing today. The first question we asked was what people see as the biggest challenge they'll be facing in implementing the new law, and here's what I think is really interesting, is that 36%, the largest section, said, nothing, no problems, no concerns, nothing at all, we got this covered. I want to ask all those people who said that at the end of today's webinar if they still feel that way. There's probably a lot more behind this than some people realize to make this work. There's a host of other issues, record keeping, which we're going to focus on a lot today, tracking hours worked, and some other areas as well. The next question we asked was, if you have employees that have not been previously entitled to paid sick leave, and almost half, 42%, indicated that, you do have some employees who are now going to be entitled to paid sick leave who weren't in the past. And it'll be interesting because a lot of the questions that you're going to be thinking through, and we're going to be going over today, really do separate that way. If you have a paid sick leave plan in place or if you don't. So we're going to be looking at a lot of that today. We also asked if you've established an approach yet, a methodology for providing your paid sick leave. And most of you said, we've pretty much got that figured out, we should be okay. But there's a good chunk of you that are undecided. Maybe we'll have some guidance and some suggestions for you today that might be helpful for you in making that decision if you have not already made it yet. We also wanted to know if you're anticipating any kind of a fiscal impact on this. And a decent chunk of you feel that there could be some fiscal impact, whether it's minimal or significant. We're going to talk a little bit about this in a few minutes and have some interesting insights to share with you on this that might change your thinking on the fiscal impact a little bit. And then finally, we asked actually one of our other questions was, if you have decided yet how you will state this on your the wage statement, and most of you have that pretty much figured out, is to put it on your payroll stub, which is a requirement of this, so be aware of that. We will warn you and remind you a couple times throughout the webinar this morning to be sure you're working with your payroll company on this. The final question we asked you was about do you have any thoughts about potential misuse of paid sick leave through your employee base? And close to 50% of you thought that there could be some of that. We'll have some thoughts on that. We'll share a couple of tips on that. And we're going to also, interestingly, discuss some things that are not yet clarified in this new law to preventing misuse. So that kind of takes us through our survey that we conducted recently. With that, I'm going to turn this over to my colleague, Mr. Matt Bartosiak. Take it away, Matt.
Thank you, Bill, and good morning, everybody. Yes, it's true. Paid sick leave law has presented us a lot of questions. There are some, I tell you at the outset that there are some questions that are still unanswered. So in some cases, I'll have to talk about what possible interpretations could be of certain aspects of the law, and always a conservative approach to the problem, to this law, is certainly advised. Well, here we are on the slide. Obviously, well, there's the name of the act. The effective date, as you can see, well, there are two effective dates. January 1 for posting and notices. Those notices, when I say notices here, we're talking about those wage theft protection notices that you have to give to non-exempt employees. I will suggest later on, as we move on, that if you make changes to your existing policies, I think it's wise to send those out, even though you have them in the handbook. Just send them out to your employees and tell them about any changes. I would send it by email. Effective date, accruals. We're going to spend a lot of time on accruals. That starts July 1. Covered employees. Well, let's go. Who the heck is covered here? Well, this is like workers' comp. All employees, they cover everybody, regardless of the size. There are just a very, very few exceptions. And before I go into here, I just want to remind you that we talk about a year, as discussed under this law, you might have to make a note, is any 12-month period. When you're trying to meet the requirements of this law, you could use an anniversary, calendar year. You could use a fiscal year, any 12-month period. Just keep that in mind. Make a little note for yourself. AB 304 is a law that's introduced now. It may very well make changes. We're going to talk about those at the end because now it's just a possibility. We'll talk about that at the end. Let's talk about the exemptions a little bit in depth. Who does not have to obey this law? Collective bargaining agreements. If you have a collective bargaining agreement, you're exempted, but you have to address sick leave or PTO and meet certain other conditions. The other conditions really are the same as construction industry. You have to have regular hourly rates, not less than 30% of California minimum wage. You have to have premium rates for all overtime hours worked. And the CBA, that stands for collective bargaining agreements, either, here's choices, you either entered into it before 1/1/15 or it expressly waived the requirements of the law. You'll have to talk about your negotiators and your advisors about your contract. They can expressly waive it, as B talks about, but it must provide for wages, hours of work, and working conditions. Also, the construction industry has to have a contract, union contract there. In-home health care workers, publicly funded. Don't get confused here. We're not talking about private households employing maids or home health care workers. These are publicly funded. You're talking about people who get assistance because they're on Social Security or they're on Medicaid. There's certainly definitions of in-depth definitions of in-home health care workers. The exempted ones, again, are those that are publicly funded. And, of course, the last one, flight deck and cabin crew members covered under the Federal Railway Act and receiving time off equivalent to AB 1522. Now, who is covered? This slide talks about workers. All workers who after July 1st, 2015, work 30 or more days within a year in California. In California. Now, as I designed these slides, I inserted aspects of municipal ordinances, other sick leave mandates that cities have, and I pointed out where there are differences. So when you see Oakland or San Diego or San Francisco, you know, if you're not there, forget about it, but it's just a quick reminder of those people of the difference between that municipal ordinance and the state law. Okay, so Oakland, employees who work 2 or more hours in a week. The state law covers all workers, exempt and non-exempt, full-time, part-time, per diem employees, seasonal, and temp employees. So we're going to talk about seasonal maybe a little bit more in depth either, but everybody's covered. Temp employees. Temp employees from agencies. The first bullet is basically saying if you have an employee from a temp agency and you are giving ongoing daily supervision, as I say in the parenthetical statement, you have what is called joint employment. There is a joint employment relationship. If you have a joint employment relationship, you both sit in the seat as an employee regarding those people. Now, when somebody comes on as a temp employee, who do I obey? The sick leave, or do I obey our sick leave policy, or do I obey maybe the one of the temp agency? Make that a contractual item, which one you're going to obey. And many people will follow the policy of the temp agency, but you could also follow the policy of the client company. You now remember, you can also have, and I'll talk about this a little bit later, you can have a different sick leave policy. You can have different benefits for different types of employees. Temp is certainly a different classification than full-time regular. So if you want to have, if you're going to do the temp from the agency and have them subject to your policies, you can have a separate one for them if you wish. Otherwise, you follow the temp agency policy. Just make sure you talk about that with the agency you're contracted, okay? Remember, regarding your agencies, you want to be sure that they're obeying workers' comp law, the Affordable Care Act, and just be sure about these sick days. If you're going to rely on their sick pay plan, make sure they obey the law, meet the minimum requirements. Temp to hire. If a temp, here's some questions here. If a temp worked more than 90 days and is converted to regular employee, do they immediately get to use sick leave? Well, let's put it this way. You count the 90 days that were served as technically the temp agency employee. You give credit to those 90 days when you change them to a full-time regular. So those 90 days, let's say it like this, are as if they were on your payroll. Those 90 days in this question would be as if they were on your payroll and you were cutting their check. This is going to be, we're on accrual now, and this is going to be a lot of information, and we get most of our questions about this. What is the basic requirement per this statute? 1 hour for every 30 hours worked, including overtime hours and no fractions used. You don't get to use let's say half an hour or 50 minutes. I would use just whole numbers. Exempt employees. Obviously, with exempt employees, most places don't track them. So you can assume 40 hours worked each week, unless the normal work week is less than 40 hours. But you can assume 40 hours per week worked on as an exempt employee. A 40-hour week, I just put that in there so you could do the math. I helped you with the math. A 40-hour work week accrues 1.33 hours per week, you know, and there's a different formula, of course, if the work week is less than that. If work hours or hours worked are tracked, then you count all the worked hours. Before we go to the next slide, I just want to remind you that if you track hours of exempt people, then you have to use all the hours worked. And that's a possibility. I've been here, I've been here since 1980, but I left a little bit to go to Aerojet, and I was doing compensation for them. When I worked at Aerojet as an exempt person, I had to track all my hours because they were charged to different contracts that we were working on. So in that case, even though I was exempt, they had all my hours. In this situation, they'd have to count all my hours worked. Caps on accrual. Accrued time must carry over to a cap of 48 hours or 6 days, okay? And the next bullet, the cap is 6 days or 48 hours. But here's the rub. You can limit the use in any 1 year to 3 days or 24 hours. So, hey, if you've got a cap of 48 hours or 6 days, well, what happens to the remainder above 3 days or 24 hours? That just means that it's carried over. They can use it the first of the next year. So the cap is 6 days, 48 hours. But anything beyond 24 hours or 3 days is carried over to the next year. If you're in San Francisco or Oakland, the cap must be at least 72 hours for employees with 10 plus, and 44 small hours, obviously less than 10. And in SF in Oakland, sorry, can we go back? Employee may use all sick leave up to the cap at any time. San Diego, the cap is 40 hours, and the cap carryover is allowed. Accrual and cap, 3 options. Somehow mark that this is mark on your pieces of paper that you're writing on, or if you can write on your computer somewhere as you're looking at this stuff. This is a crucial slide. This is a crucial slide. Because employers, you have 3 options, and here we go. Well, you can follow the rules of AB 1522, which means what? We talked about it. 1 hour for every 30 hours worked, 3 days or 24 hours, carry over to a cap of 6 days, 40 hours. And if you use this option, if you have the hours tracked, calculated for workers, you have to track those hours regarding calculation of equivalent sick leave. Front loading. This is one of the options that you can use. If you provide 3 days or 24 hours the beginning of every year, that's immediately available, there's no accrual, there's no yearly carryover, there's no cap. The important thing is here is in plain English, you give them 3 days, 24 hours at the beginning of every year, forget about the cap. You don't have the cap. But you're going to, the beauty of this is there's no tracking allowed. I don't have to track what he earned because I'm giving everybody 3 days and 24 hours at the beginning of every year. That's the beauty of it. A lot of times this is very advantageous for large employees, employers if they have a problem with calculating individual amounts. Or, and a lot of people will probably take this option, use your existing employer policy. You can use that if you do either A or B. What's A? You obey, you honor AB 1522 rules on accrual, on carryover, accrual again, and other requirements. Or you provide at least 3 days or 24 hours per year at the beginning. Now, big question, huge question. That's all the law says is you provide at least 3 days or 24 hours per year. Basically, that's what it says. They were silent on whether or not you can keep your own accrual. The law doesn't address that. And by the way, the state issued FAQs on this, and they were silent on this. However, and I read different opinions, I subscribe, and this is an opinion, you have to remember this. Some legal experts argue that this option allows an employer to use its own accrual method, but you still must track. So I looked at all these opinions, and the only one that made sense to me is the one that allows you to keep your own accrual method. That's the opinion that I would subscribe to, but you have to know that it's an opinion. Because if you don't, if you have to follow the accrual laid out by the law, are you really obeying the requirements of the law? One other interpretation of this is to follow the accrual of the law of AB 1522 up to 3 days or 24 hours, up to 3 days and 24 hours. If you want to be extra safe, you could do that. Let's focus on front loading a little bit more. And here we have some questions. When is a new hire eligible to use front load paid sick leave? I would say 90 days from the first day of work. Yes, and the state's FAQs actually say that as well. I'm getting tons of questions on the second bullet. You know, what about this transition year of 2015? That's the one that causes a lot of headaches. We don't know what the heck to do. What do I do with paid sick leave already used? My opinion is, and I think you're okay, is the law says, hey, as long as you give 3 days, 24 hours, you are okay. So my question is, did you give at least 3 days, 24 hours in 2015? The law says you're okay at that, and you follow the opinion that you could follow your own accrual, or you're being extra conservative and just using AB 1522's accrual rate just for the first 3 days and 24 hours. But if you already have it, you're home free. Front loading 2015. How much time to provide for 7/1 to 12/31? I'm assuming here that these people who asked this question, the third bullet, are going to go on a calendar plan. That's why they're using the 12/31. Well, you got to start obeying the accrual. If you don't already have 3 days or 24 hours, right? If you don't already have that, then and you're starting from scratch, well, what would I do? I would either do 1 hour for every 30 hours until 12/31, or 3 days, 24 hours. Up front, having the new employee wait 90 days, and making the decision whether or not you're going to follow the interpretation that you use your own accrual, or you're going to be extra safe and use the AB 1522's formula once again for up to 3 days and 24 hours.
And then, Matt, I know that the other option that's come up quite a bit is just go ahead and bite the bullet and give the full 3 days, 24 hours for the second half of 2015.
Yes.
So either one of those options.
Yes. Yeah, that's what I meant to say with 3 days, 24 hours. Yes, thank you for the clarification. Bill is reminding us that 3 days, 24 hours would be front-loaded. So advantages, disadvantages. I think the big advantage is the tracking. Do you want to track or do you not want to track? That's probably the big advantage. If you give it up front and people have it, let's say if the people have 3 days, 24 hours, well, you know, if they know they have it, maybe it will dwindle down on people. Maybe it'll dwindle down on people assuming that they have some emergency and you have to give me the time off. So you make the decision up there. If they have the 3 days or 24 hours, I think it's the advantage is the tracking. Basically, a disadvantage is that, well, you've got to give it up front, and if people have quick turnaround, if they leave the job, especially these new hires, well, that might be somewhat disadvantage. But remember, they can't use it until they're there 90 days anyway. So you'd have to, you have to accept that disadvantage, but it would only occur to you regarding new hires after 90 days, because again, they can't use it. Here we have more questions, multiple methods. We're getting this a lot. Can we use different methods for different groups of employees? For example, one method for exempt, one for non-exempt. Sure, go ahead. You're always allowed to have different benefits for different groups of employees that are differentiated according to a business variable. They work in Orange County, these people work in LA, these people are office, those people are factory, exempt, non-exempt, these people are managerial, these people are sub-managerial, any business classification. Can we offer different amounts of paid leave? So the first question, they seem similar, but they're really not. One says, can I have different methods? of calculating sick leave? Yes. And the second message says, can we offer different amounts of paid sick leave? Yes. The answer to both of these questions is yes, as long as you have objective business criteria to determine the groups. And you can have different amounts just as long as you obey, again, the minimum requirements. Okay. How do I part-time accruals, part-time people? How do I grant sick leave to a part-time employee that works in a regular schedule, works occasionally, a few days per month? Well, you're going to see very clearly that they're paid at the hourly rate, but the answer is a lot simpler than a lot of people assume. What I'm trying to say on question 1 is just you do the math. 1 hour for every 30 hours of work. 1 hour for every 30 hours of work. So obviously the guy who works 30, 40 hours a week is going to accrue 30 hours in 1 hour faster than somebody who has 2 hours that is here 2 hours every other week, right? Just do the simple math. Just do the simple math. 1 hour for every 30 hours work. A lot of people are trying to are confused, unfortunately. They try to figure some flat amount or something. It's much simpler than that. Do the calculation. 1 hour for 30 hours work, or you're front-loading here. Okay. If a full-time employee works 34 hours a week and on a part-time works 22.5, how much sick time should each get? Again, I think it's the same answer as, I know it's the same answer as bullet 1. Just do the math. Don't get confused or fall in the trap where somehow you're trying to figure some flat amount. Do the simple math. 1 hour for every 30 hours. It's much more simpler than a lot of people assume. Don't assume sort of flat business. Do the math or do the 24 hours. PTO plans are plans. Specifically, the law allows PTO plans as long as the PTO plan satisfies the accrual, carryover, and other requirements of AB 1522. Or your PTO plan puts the full amount of leave into an employee's leave bank at the beginning of each year. And then there's a kind of a parenthetical statement at the end, which is not in parentheses. The state's FAQ states, although the FAQ answers state's full amount, the law requires only 3 days or 24 hours. What I'm trying to say here is this answer on the state might be misinterpreted by people to say full amount. Well, we give 6 days full amount, so I have to give 6 days up front? No. Full amount means 3 days, at least 3 days or 24 hours up front. Or if you want to, give more. I got to stay here on this slide for a moment and go into this question. If I use a PTO plan, do I have to be able to prove that at least 3 days, 24 hours per year was used for sick leave? I've read several legal opinions that say, hey, it might be wise that when they use a PTO plan for a sick day, that somehow that's documented. So if anybody comes to me and says, you know, I always used it for vacation, and they try to give you a problem, one option, a considerable option again, is to track or to at least document that they took 3 days, 24 hours. Another one of PTO. If we currently offer a PTO plan that accrues at 3 days per 12-month period and carries up over to 6 days, is it sufficient? Yes, we're back to the same question of they give you 3 days, okay? And I'm going to assume that's at least 24 hours. Let's make that assumption. If you give that, and we're back to the discussion is that's okay, but the question arises, did I have to use the accrual method of the state, 1 hour for every 30 hours, or a front load, or can I interpret the state that says as long as the state's, the law's statement that as long as you give 3 days, 24 hours in a year, you're fine? Again, it's a difference of opinion. I follow the legal opinion that says you should be able to follow your old accrual. If you're nervous about that because it's not in print, again, the option for you to use, you're going to be very careful, is at least for the first 3 days and 24 hours to use the either front load method or 1 hour for every 30 hours worked. if you're nervous that, Matt gave an opinion here, and I want zero risk. You want zero risk? The first 3 days, 24 hours, obey the accruals of the law. After that, do your own thing. Front loading. Again, if an existing plan gives full-time employees 32 hours of sick leave front-loaded on the date of their hire, and subsequently, they're nice, they give a date of hire, and subsequently on January 1st of each year, is it already in compliance? Or do you have to be just switched to anniversary date? Again, the answer to this question, as you posed it to me, is you're already in compliance. But they're really asking me something in the last phrase, is it already in compliance or we need to be switched to an anniversary year? Remember, as we said very, very early on, the 12-month period designation, you call it. Is it fiscal? Is it anniversary? Is it calendar? You call it. It's got to be a 12-month period. Payout and forfeiture. Sick leave cannot be forfeited by active employees. Okay? Now, here's a big hole. Here's a big question mark. Here's a big I don't know. The law does not address situations when an employer pays out unused sick leave. It's silent on that. So we'll have to look for further clarification. But I can't give any direction. There's no direction given either in the statute or in the DLSC's, the state's FAQs. Pay it out at termination. I put that on bold just so it would jump out at you when you read the slides later. Pay out at termination. It's not required, but remember, if the employee is rehired within 1 year, then all accrued time is immediately available. There's no 90-day waiting period when the guy comes back. This, and I'm going to stop here for a moment, this may especially affect these employees who come back. They go, they come back, they go, they come back, some or whatever. So especially for those people, you're going to have to do a little calculation to see if they've come back here. Then I gotta put back in your bank all accrued leave, and you don't have to wait for 90 days. 90 days. Accrual calculation. Okay. Basically, I'm saying counting hours versus days or days versus hours. Use hours versus days, whichever yields more time. If you have an alternative work week, you have a 410 or something like that, if the employee works 4 days and 10 hours, well, how do I approach the cap, or the 3 days, 24 hours per year? Well, here the total cap equals 60 hours. The cap of 6 days, the cap, we're talking about a cap, it is 6 days times the 10 hours. So they have 60 hours. So you obey the days or the hours, whichever is more beneficial to the employee. Hey, last bullet. What if the workday is less than 8 hours? If you work less than 8 hours, then you've got to bring them up. You bring them up. Use 24 hours at cap of 48 hours. Use a cap of 24 hours and a cap of 40. Use 24 hours a year and a cap of 40 hours. It yields more time than using the days. This is where you have, a lot of people have 37.5 hourly work week. Purposes for use. What can they use it for? Well, this may be taken by the employee or family member for preventative care, existing health condition, specified purposes. Qualified, and if you want more detailed information on specified purposes, give me an email, I'll send them to you. It's an employee. Who gets to use it? A parent. Step-parent specifically included, also in loco parentis. And again, loco parentis, Latin term for meaning standing in the place of the parent. You could use it for such a person. For example, my parents died when I was 3 years old. But my aunt brought me up, and she stood in the place of my parent. Well, now when my aunt is sick because she brought me up, she had stood in loco parentis, I can use it for her. Child, stepchild specifically included, also in loco parentis. If you are bringing up somebody for whom you are not the parent, you bring, your brother died in Iraq. Sorry for the sad comment, but if somebody died and you were bringing up that, maybe you're bringing up the niece or the nephew, then you could do it for them, the spouse or the registered domestic partner. Oakland, listen, if there's no spouse or domestic partner in Oakland, you may designate or name someone for whom to take the sick days. Grandparent and grandchild. I want to stop here. Many sick leave programs, benefit programs, as they exist now, do not grant time off for grandparent, grandchild. So you should know that if you're sitting there saying, hey, we already got that, they get 3 hours, 24 hours a year, we give a cap of much larger anyways, you've got to make sure that your sick pay plan, covers grandparent and grandchildren. Sibling. The step sibling is not addressed. I look for that. So, but I would probably allow it. I'd probably allow it. Also, don't get confused. Look at the bottom here. They can also use it for reasons related to domestic abuse, sexual assault, or stalking. And the reasons specifically related to those sad circumstances, the reasons connected to those sad circumstances are outlined in Labor Code Sections 230C and 231A. And those are things like, I've got to get medical care, or I've got to get psychological care, or I've got to get a restraining order so my ex-husband, wife doesn't come around, or I've got to make arrangements for child care or something because now, the family is split, or I got to go to court for the sexual assault. So those answers are there explicitly listed. Again, if you'd like for me to send them, I'm happy to do so. When am I eligible to use? The employee may use accrue time on the 90th day of employment, and you can immediately use it if it's front loaded. Now let's stop here. Remember, if you're a new employee and it's front loaded, you can make them wait the 90 days to use the front loaded. Okay? If you need that, I said that in a previous slide. You might want to make a note here. If you're talking about a new employee, newly hired employee, and you front load, then you can make them wait 90 days. Oakland, pay attention. The 90-day rule only applies to employees hired after March 2nd, 2015. Stephen?
There we go.
Notification from employee. So what kind of notice can I demand from these people? Reasonable advance notice is required for foreseeable leave. Otherwise, as soon as practical. Okay, I'm going to have in-office procedure, and I'm going to do it in a month and a half. You should be able to get notice from that, okay? But a lot of times they're going to be sick and they're going to call you up. The employer may not require, as a condition of using leave, that the employee searches for or finds a replacement worker. Okay. San Diego. If the leave is foreseeable, 7 days notice. If not foreseeable, as soon as practical. Continue. Documentation. The law doesn't talk about it. It does not address whether an employee may require medical documentation as a condition of using paid leave. It doesn't specifically say yes. It doesn't specifically say no. And I've been reading legal opinions that says, all right, since it doesn't cover it, you can ask it only if it's allowed to you under another law, maybe like ADA or FMLA, okay? That's one opinion. Other legal opinions is that follow your regular policy. And you have to make a decision under that. I really think a reasonable interpretation is to require the same medical documentation. If you're scared, if you don't want that opinion, then only ask for medical documentation when another law allows it. But I think it's very reasonable to follow your own policy. Usage. Well, how much can I use at any one time? This is what this is asking. The employee may set a reasonable minimum usage increment of no less than 2 hours. You got to go out for 2 hours. Partial days are okay for exempt employees. You can use partial days for exempt employees. Remember, and I think I get into it later on, I'll just say for now, regarding the second bullet, that if the exempt person shows up for 5 minutes, they get all their money for the whole day. I'll talk later on about how you would pay that out, because you could draw that from the hours missed from a paid sick account if it exists. I'll go into that a little more in depth later. Let's go on to San Francisco. One minimum increment allowed 1 hour. And you can allow a larger minimum requirement based on certain circumstances. Oakland, again, not directly address the issue, but may be interpreted to grant minimum usage of not more than 1 hour. Pay. How do I pay the sick hour, the sick day? Well, I underlined the first bullet here because I wanted you to make sure you notice that you can pay no later than the payday for the next regular payroll period after the sick leave is taken. What does that say in plain English? If I used it in this payroll period, you only have to make sure you pay it on the payroll period's check, not this payroll period's check, the following payroll period's check. I think I tried to make that very, very clear. Okay, the paid sick days must be paid at the same wage as the employee normally earns during regular work hours. The rate of pay must be the employee's hourly wage. That's what the statute says. Okay, I'm going to stop here. When you look at the state's FAQs, they say paid at the regular hourly rate. Well, I got to stop here and tell you that the regular rate is a legal term. The regular rate by law is that rate on which overtime must be earned. And for generally for hourly people, you're going to divide the total compensation, the bonuses, things like that, and divide by total hours to get the regular hourly rate. That's what it says in the FAQs. But it doesn't say that in the statute. It says hourly wage. It says hourly wage. If you go to the horse's mouth, if you go to the exact statute, it says hourly wage, which is not the regular rate. You know, in San Francisco, they allow you to pay a sick hour at the equivalent of 2 times the FS minimum wage. Well, remember, if you're up there, you will have to acquiesce to the state requirement to pay at the employee's hourly rate. Include bonus or gratuities again. That stuff is not even addressed. It's not addressed at all. The statute says hourly rate. It doesn't use the term regular rate. So the statute of hourly rate would be interpreted as the hourly rate that they work at, minus incentives, things like that. Here we go. They do address, in the law and in the FAQs of the state, they do address people who are paid commission or piece rate. If you're paid commission or piece rate, then you divide the total compensation for the previous 90 calendar days. They said use the last 90 calendar days, and you divide that by the number of hours worked and pay this rate. Okay? So then the last 2 bullets are examples. The second bullet is a piece rate example. And they give you the formula here. The guy has a piece rate of 36 cents per square foot for 16,500 square foot during 4 hours of work in a 90-day. Well, forget about that. The bottom line here, you don't have to try to do that math. Forget about that. All you have to know for the second bullet is, hey, the guy earned $5,940 on piece rate in the last 90 days. That's all you need to know. Well, what do I pay him? The hourly rate is $5,940 divided by $400. $14.85 per hour. And the last bullet here is the one based on commission. You're going to go back 90 days again, and here in the example, she worked 48 hours and earned $9,000. All I'm going to remember here is in the last 90 days, she earned $9,000. Her hourly rate is $9,000 divided by 480 hours, and it's $18.75 per hour. Here we go to the itemized wage statements. Show available paid sick leave or PTO. And I want to stop here because I've noticed this, and since I've noticed it, I've had several questions. a lot of times lawyers call me, see what I think. It says available. To me, available means I can use it, right? Does it mean accrued? It doesn't say accrued, it says available. But this is kind of a big question mark. All right, I'm going to show the guy that what's available, but he doesn't know what's accrued, and maybe I'd like to, he should know what's accrued. That's good information to give somebody. So if I were there, I would give available paid sick leave, what they can take, and I'd try to put somewhere what they're accrued but not available yet, accrued but not available yet. If you push me, is that say you got to put the accrued there? It doesn't say that. It says available. But I want to give complete information. So if at all possible, I'm going to give available now, and then I'm going to give accrued but not available yet. Alternatively, a lot of times people have a lot of questions here about people having problems putting this stuff on the itemized wage statement. If that's a big hassle, or I don't know, your payroll service vendor is going to charge you, $10 million to do it, then maybe it'd be more cost efficient to give a separate document, which you are allowed to do, specifically allowed in the law. A showing of bill paid sick leave. Now remember, if you choose a separate document, that's going to be given to the employee every payday along with the paycheck. Every payday, every payday. I like to say that because I'm getting questions on it. Every payday along with the paycheck.
Matt, before we move off of that topic too, just a reminder, because this has come up quite a bit, is with your whoever's doing your payroll for you, if you have a payroll company doing the payroll, don't expect that they're going to know this. Some of them will tell you that they're on top of it, and they very well may be, but don't just expect them to make these changes and have your pay stubs adjusted appropriately. Work with them, talk to them. You should be doing that now. So whatever your decision is and whatever your approach is going to be documented. I know a lot of the payroll firms are not California-based and may have even more trouble making the adjustments to covering this. And we are getting different stories from some of the major payroll companies. In some cases, they're saying, yeah, not a problem, we got it covered. Other times, we're being told, oh, wait, what is that? And we need to learn about that. Help us to understand it. So do talk to your payroll company, whoever it may be.
Thank you. We're talking about the notice here. Again, we're talking about the wage theft prevention notice you have to give to non-exempt people, right? Revised wage notice has information about it. Take the labor commissioners right there. It's required for all non-exempt employees to have the revised notice because there's a little blurb there about their rights for sick leave. And it has to maintain that information. I wouldn't revise my own. I would just use the one there connected to that link. Posting, you got to do this January 1st, 2015, and there is where it's available, right there. Posted where obviously workers see it.
And this is also, the poster is also available for Employers Group members. If you go onto the BNA section of the Employers Group website, there is a notices and posters section on the right side of the screen there, and you can click on that and find it and download it right there. Again, that was supposed to have been posted on January 1st, but we won't tell anybody in case you're still looking for it.
Yeah, that's a good reminder, Bill. You know, if you're a member, you get to use BNA Research Services. That the Bureau of National Affairs very highly recognized research organization, and they have tons of stuff there. And they even break out laws by state. You get stuff on California. Really valuable. Use our website. It's really good. Let's go to penalties. Well, what's the bad news? If you need to shake the corner office, the corner office, the CEO or the COO, and scare the heck out of them, well, here you go. Employees can file claims with the Labor Commissioner for not providing paid sick days or retaliation. You have to be very careful about retaliation. I'm going to repeat it later on, with your supervisors or your managers who don't know the law, and they're hitting Joe over the head because of sick days. You know, if you're in HR, you know who gets into trouble. It's the frontline people that get you in trouble. I mean, HR makes mistakes, certainly, but it's those frontline people that really get in trouble. Liability for not providing. There's a dollar value here. 3 times value of sick days, or $250, whichever is greater. up to $4,000, okay, the dollar value of sick days. So obviously talking about individual employees. Liability for other harm. They didn't get the promotion. They're being discriminated. They're being harassed for using sick leave. You can get a civil penalty up to $50 a day for that other harm, up to a maximum of $4,000. Now they're going to zap you again. Last bullet. They can also charge you for the time they took to investigate the claim. $50 per employee per day. So you need to scare somebody, this is the slide. Compliance tips. This, along with those 3 options slide, was very, very important. This is very important as well. This is your things that you have to be careful of doing. Now, you have to determine which employee option the company will use, right? Remember the slide 3 options? You have to review and, as necessary, revise existing paid sick leave or PTO policies and procedures to ensure compliance with the new act. This is what I would do. Any revision, send you know, even if it's in your handbook, send it by email. And indeed, I believe that the statute is a requirement to make employees aware of change. So when you change it, even the only thing you do is you add the grandparents, I would send it by email. And if you want to say, hey, it's in our handbook, that's what I would do to everybody. Develop paid sick time policy that complies with the Act, obviously. You have to develop a paid sick leave policy. Look at the magic words, second line, who are not covered. Bullet 3 talks about people that you never gave sick leave before. So you either, what do? You fold them in, or you devise, design an existing paid sick leave policy for part-time, temp, seasonal. And remember, as I said before, you can have different paid sick leave policies for different classification employees. Part-time is different than temp. Temp is different than seasonal, but you're still going to make the minimum requirements. But don't get confused. You can have existing separate policies for separate types of employees.
And just again to stress, because that question is coming up quite a bit, as long as it meets the minimum requirements of the statute, you can have quite a few different policies if you need to.
Okay. If you have municipal ordinances in your city, obviously you have to integrate them or see how they compare. Where differences occur, you honor the rules that most benefits the employees. If you need to circle that, you circle that. Where something's embedded regarding one variable or factor, use that factor or variable for the employee. Review company. This is important. I think this is very important because, again, as I said about frontline people getting in trouble. Review company policies concerning anti-retaliation, attendance, conduct, and discipline to prevent retaliation under the Act. So you've got to review these policies, and when managers or supervisors are giving performance appraisals, if they're talking about using sick leave and it was protected sick leave, and that's why he's getting a lower score, you got to have your antenna up for that, right? So do make sure that you talk about your procedures and policies and how they may disadvantage an employee who uses their legal rights, because you've got to clean that up. Next bullet. Make sure, obviously, that the company complies with the notice, the posting, and the record keeping. Okay, you're going to see record keeping in a moment, but generally it requires 3 years, but you'll see that in a moment. And monitor the Division of Labor's websites. Okay. This is a question a lot of people don't remember. Remote workers. Look at the word in the third bullet, remote workers. What do I do with remote workers regarding all that stuff? You know what I would do? Just send the revised policy by email to them. That's what I would do. And I'd probably send the posting requirement. A lot of times what people do when they have remote workers, a lot of times they just, one person is like working in his house. I just copy the posters, put them in a binder, or just give them to them. That's all you do. Review the Waste Theft Prevention Act notice, right? To update the notice to reflect the Act's requirements. Well, I'm not going to update the notice. I'm going to use the template. That's being the COBRA expert for the firm. I can remember when people would try to write their own COBRA notices and election forms, and I said to myself, "Are you kidding?" You know, I would use the template. Let's go. Ensure that benefits, timekeeping, payroll systems are ready to properly calculate, track, and report accrued and unused paid sick leave. Be prepared for the record-keeping requirement, which is 3 years. I would suggest 4. The law says 3. Ensure that itemized wage statements or some other written notice will be provided showing available sick hours. Again, you got to show available sick hours. Remember the discussion about available versus accrued. If the law says available, it doesn't say accrued, I give complete information even though I legally don't have to. I'd say, hey, Joe, here's what available, here's what accrued, but you can't use yet. That's what I would do, but the law just says available.
And Matt, just to remind everybody too about electronic pay systems. So if I don't get an actual physical pay check with a pay stub, the electronic tracking is sufficient, correct?
As long as I can download my itemized wage statements, that's fine. Just standing on here just for a moment, just popped in my head, somebody asked me, well, how does this do it now? I have to show vacation too? No, you don't have to show vacation on a wage statement, itemized wage. No, forget about that. These requirements are for sick leave, if you will. Got to train, please, this is so important. Again, I've said it before, I'll say it again. You got to train your supervisor, your manager, and your payroll employees on this. Again, who's going to get you in trouble? Those supervisor, managerial people, those people who direct other employees who don't know the employee's legal rights. You got to do this. I would even have a little training session. I'd be very careful to make sure they have this knowledge. And again, monitor the DLSE website. And now we're going to talk about calculating the fiscal impact, but we're going to have, I'm going to ask Bill to do this.
Thanks, Matt. This is a question that's come up a few different times, and it's interesting. I've had the opportunity to sit down with Robert Campbell in our resource library, Juan Garcia, who runs our compensation research department. And it seemed like a simple question when it came up initially. It's like, how do we figure out what this is going to cost us, providing paid sick leave to employees who were not previously covered by this? And if you do have to budget for 2016, if you're starting to think about that, or effective July 1st, if that's how your fiscal year runs, if you're being asked to do that and you need to calculate the fiscal impact, how do you do it? I'll give you a little spoiler alert here. The answer is there really is no accurate method for doing this. In our research, we found that you can calculate, you can look at surveys that show that the average cost of paid sick leave for a manufacturing employee in California is about 21 cents per hour, which works out to $427 per year. So theoretically, you would think, well, gee, we just multiply that by the number of people that are now going to be covered under paid sick leave that fall into that category, and that'll tell us how to annualize it. It's not true. Not true at all. The existing data that is out there is not based on the same criteria that we're going to be using for this. We don't know how many hours were provided to those employees, how many paid sick hours were provided to those employees. We don't know what percentage of them, of those hours are actually being taken. In many cases, it's going to be 5 to 10 days per year that are provided in existing plans. Now we're maybe going to be providing people with 3. We know that they take a little bit over 50% of the paid sick time provided ordinarily. We don't know if that's still going to be the case now. We don't know how much it's going to cost us to replace those employees on a day-to-day basis if we need to, and what additional costs are going to come if there will be a loss of productivity caused by that as well. And additionally, there's an administrative cost of tracking paid sick time, which Matt has been focusing on quite a bit when you put all that together. So it's a little bit trickier than it sometimes seems to be. There's another angle to this too, which is that there is a positive side to this. We don't want to look at this as just a negative, like, hey, now we got to provide paid sick leave to people. Well, there's a reason why this has come about, and that is because people get sick. And right now you've got people, if you're not providing this, you've got people showing up to work who are sick. When they show up to work and they're sick, well, it's going to take them longer to recover during the time that they're trying to recover. There's probably going to be a decrease in productivity. You're also going to see the issue of a term that we're seeing a lot, presenteeism. People showing up, they're sick, they're unable to perform the work at the standard you expect them to be able to perform at. we're expecting to see a decrease in that with this new law. Theoretically, this should also be improving morale and decreasing turnover to a certain extent when people know that it's not going to cost them money out of their pockets if they have to stay home to take care of a sick child, as Matt mentioned in terms of when you're eligible to take this. So don't look at this as something that is going to have a tremendously negative fiscal impact. There will be some. Our studies out there, take it with a grain of salt, but studies that will tell you that there's a positive return on the investment of providing this. Not so sure if that's true, but I think that in putting all this together and trying to come up with a number, in the end we just kind of figure the number is minimal. That's about as far as we can get and as detailed as we can get. One other issue we want to look at too is potential misuse, and this has been coming up quite a bit. And there's a couple of areas for anyone that has employees that fall into these categories that really stand out or jump out at us. Things like, well, it's getting to be holiday time. Are you going to see an increase in paid sick time when you get closer to holidays? If you've got people who live far away from where your office is, where your location is, are they going to suddenly be off on Friday before they have Monday and Tuesday off of the following week? Look out for those types of things. Student workers, if you have either student workers in your organization, as a lot of our members do, or employees who are still students, if I'm a student and it's finals week and I can get paid to stay home and study, I might think about that. And the other area to look at is intermittent leave, if there might be an interplay between this and people who are oftentimes out on intermittent leave, if you're going to see paid sick time being substituted for that as well. Also think about in front-loading methodologies, and this is a little bit tougher to calculate, but if you have a lot of turnover, if you're in a high turnover environment and you're front-loading, and I know I'm not going to be staying too long in this position, I'm just here until I move on to something else, I might want to take my 3 paid sick days sooner rather than later. So you might see a repetition of paid sick leave in a specific position if you are front-loading it because it's out there. You're providing additional paid time to your employees. So just a couple of things to look at. And I'm going to turn it back over to Matt when we look at the corollary of that, which is what can we ask for from employees when they want to be out, when they ask to be out on paid sick time.
I wanted to stay here on this slide, Bill, because of the paid holiday. A lot of companies out there have a law that's a rule that says, hey, if you're absent the day before, the day after a holiday, you're not going to get a holiday pay. I see that all the time. I just want to make one statement. You have to be careful with exempt employees. You cannot hold that rule for exempt employees because they have to be paid for holidays under the theory that they are available for you and you shut the doors. So you cannot apply that rule that says you don't get paid the day before, the day after if you don't come in. You can't apply that for the holiday people. And another thing just popped my head, and this is good that it popped my head so I can remind you. Some companies have a policy that says once you give notice, you cannot use a sick day. You better be careful of that. If you have a policy that says, and I've seen it before, no sick days once you've given notice, this law is going to interrupt with that. So you have to be able to look at that policy if you have that, and remember again that exempt people have to be paid for holidays. Bill, did you want to take this?
Well, I think we've talked about this a little bit and addressed these main points. But again, it's just to reiterate, be sure you're working with your payroll provider, and if you do it internally with the people within your organization that do the payroll, to make sure that this is going to be fixed. Try to get a sample. Make sure that they're showing you exactly what's going to be stated on this and how they're going to track it. And you've worked closely with your payroll provider.
Questions? Should taking a day of paid sick leave disqualify an employee from receiving a perfect attendance bonus? I'm sorry, it's not addressed in the statute. It's not addressed in the FAQs. Now, the word perfect attendance bonus is not addressed at all. So the answer is, I'm sorry, I don't know. If you want to be very cautious, conservative, until there's some sort of clarification here, don't do it. At least for the, the 3 days, 24 hours, right? Don't do it at least for the 3 days, 24 hours. No, you got to be careful about that. I'm sorry, there's not an answer there. Where can we get a sample policy? Well, we have several materials we're putting together. We're going to try to get something like that out to you.
This is a question that we get a lot, and there's the challenge with a sample policy. I think everything Matt's been talking about this morning helps you to understand just how complex this is and how personal to each organization your approach is going to be on this. There are some templates out there. I know that Richard Simmons has an entire book that came out on the new paid sick leave law. I believe it came out in January or February. It is available through Employers Group. He does have a sample policy in it, but you can't just take somebody's sample policy or template and apply it to your company. It's going to require quite a bit of individualized work. So do plan to spend some time on it. To Matt's point, we will be sending out to everybody that is part of this webinar a copy of the presentation, a link to the actual presentation, as well as answers to your questions that you've been typing in. So we'll be sure we address everything that comes up. And Matt is putting together some policy pointers for us on this as well.
Prognosis, AB 3304. I did say at the beginning of the presentation that there is on the back burner, there is introduced legislation here. Remember, as you go through these slides and look at them later, make sure you know or you mark somewhere that this is not law now. This is not law now. This is maybe on the horizon. And Bill, I'll hand it back to you.
Yeah, there's just a little bit to say about this. I would recommend that everybody get a copy of this legislation right now, AB 304. It's pending. And as Matt alluded to on this slide, you can see that the expectations within Employers Group is that this will pass. There are quite a few changes, little adjustments that it's going to make to paid sick leave. The prediction, and don't go to the bank with this, but we're expecting that it will pass as early as September. The governor will sign it into law, and the provisions would probably go into effect in January of 2016. So please stay tuned and please stay in touch with us on this. The best piece of advice we can give you on this, though, is don't change anything from what you're doing right now. Don't expect, hey, here's what's in the legislation, so here's what's going to happen. There probably will be some changes to what is proposed right now. It's been amended twice since it was introduced in February. We expect there'll be a little bit more back and forth on it, and there are a couple of key provisions that are part of this, and what we put together on these slides just kind of give you an indication of it. Really, there's a lot more. The one that I particularly like is the point about unlimited sick leave. If you're providing unlimited sick leave, you can just indicate unlimited on the itemized wage statement. And this has kind of been a hot topic from some of our members over the last couple of years. Gee, what if we want to just provide unlimited leave, period, and not have to track anything? That's great, and that does fit in this. I know there are a few of our members that do that, and what they're going to clarify for us on this is that you could just state unlimited on the itemized wage statement on your pay stub. So a couple other details about it, but again, take a look at the legislation. There's a lot more detail than what we have on these slides. That will be part of that. And just kind of keep this in mind going forward. Follow it, monitor it very carefully. We will certainly keep you apprised as to what's going on with this and let you know as details come out. there's a couple of questions that have come up, and I want to run a few of these past Matt because they're kind of general questions. I want to thank everybody for typing in their questions, and as we indicated, we will send out FAQs with your questions on that and make sure that we address all the specific situations that you are bringing up here. But a couple of things, Matt, that maybe in our last couple of minutes we can summarize. First of all, the status of the San Diego paid sick leave, is that in law right now, or is that still pending?
That's in law right now.
Okay. So what we're talking about is the actual law in San Diego. The other one I want to address is a little bit more about front loading, and this seems to be where most of the questions come. If you're front loading, can you talk a little bit about front loading for part-time employees? When you don't know exactly what their total hours are going to be, should you just be front loading 24 hours up front just to make sure they meet their minimum requirements?
You know, just remember one thing, and this is where a lot of people are getting confused. There's no such thing as prorating here. There's no such thing as prorating. If you are keeping notes here, because this is where I'm getting a lot of confusion, there's no prorating. You do the math. 1 hour for every 30 hours work or 24 hours front loaded. You may not like it, but it's easy to remember. You don't prorate. Don't think about flat amounts unless you're doing 3 days, 24 hours. But there's no prorating, no prorating. 1 hour for every 30 hours of work, no matter how long it takes them to get there, or 3 days, 24 hours. There's no prorating.
Excellent. And then there are a few questions that have come up about unused balances. And just if you could clarify a couple of the key points on that. Is there anything in the law that requires any kind of payout whatsoever on unused paid sick balances? And then also front loading, carrying over balances, just how there really is nothing since you're front loading. Just speak to those 2 points.
Okay, here again. The only time, just think of it this way. There's only way you have to pay out this sick leave if it is covered under a PTO plan. And that's it. You ain't got a PTO plan, no cash out. As simple as that.
Excellent. And then finally, just one last item just to get to is let's just finish up, and this will be the last area that we'll talk about, but a little bit more about the last 6 months of 2015. And let's just use this scenario. My company already front loads 40 hours of paid sick time at the beginning of the year. So we've already, on January 1st, 2015, we front loaded, everybody had 40 hours of paid sick time. Some have taken all of it, some have taken none of it, and all sorts of points in between. Now it's July 1st. Do I need to look at everybody's individual balance and make sure there's something there?
All right, the question is, the rule is, the law says, if your existing pay policy gives at least 3 days, 24 hours a year, you're okay. And then I ask myself, hey, I gave them 40 hours a year in 2015. Did I meet the requirement that I give 3 days or 24 hours in a year? Yeah, I already did it. They had it.